Can Prime Minister James Marape be the Appointments Committee Chairman under the ICAC Act 2020? Honorable members, distinguished guests, ladies and gentlemen. Today I wish to speak about a crucial question for the integrity and credibility of anti-corruption governance in Papua New Guinea. Can the Prime Minister of the day, specifically Prime Minister James Marape, serve as Chairman of the ICAC Appointments Committee under the ICAC Act 2020? And indeed, is this consistent with the constitutional and statutory safeguards intended to ensure ICAC's independence? My analysis is grounded in the ICAC Organic Law 2020, the ICAC Act/Organic Law on the Independent Commission Against Corruption, relevant constitutional provisions, and the published text of the law. I aim to show what the law does provide, how it frames the role of the Prime Minister, and whether there is any clause that forbids the Prime Minister from being the chair of the Appointments Committee. Background: the ICAC Act 2020 and its legal status. The ICAC Act, Organic Law on the Independent Commission Against Corruption 2020, was passed by the Parliament of Papua New Guinea to implement Division 8.3 of the PNG Constitution, which provides for an independent anti-corruption commission. Because it is an organic law, its status is higher than that of ordinary legislation, and changes to it require stricter procedures. Under this law, the ICAC has commissioners, deputy commissioners, an appointments committee, and an oversight committee with defined roles, powers, qualifications, disqualifications, and procedural rules. What the law does say about the Appointments Committee. Section 133 establishes the Appointments Committee. The Appointments Committee consists of A. The Prime Minister, and B. The Leader of the Opposition, and C. The Chief Justice, and D. The Chairman of the Public Services Commission, and E. The Chairperson of the Papua New Guinea Council of Churches. Section 133(3) further states, the Prime Minister is the chairperson of the Appointments Committee. Thus, the law expressly appoints the Prime Minister as chair of that committee. Section 134 defines the functions and powers. It says the Appointments Committee has the function to advise the head of state in relation to the appointment of the commissioner and the two deputy commissioners, and appointment of acting commissioner/acting deputy commissioners. Sections 135 to 138 then set procedural rules, meetings, quorum, and voting requirements. Section 138 states that the quorum is 3 members of the committee, and decisions are determined by a majority vote. Section 15 also requires that appointments must be made at a meeting of at least 4 members of the Appointments Committee and agreed by at least 4 members. Disqualifications in the ICAC Act apply only to commissioners or deputy commissioners, not to members of the Appointments Committee. Is there any section that forbids the Prime Minister from chairing? There is no clause in the ICAC Act that prohibits the Prime Minister from holding the chairperson role of the Appointments Committee. On the contrary, the law explicitly names the Prime Minister in that role. Therefore, from the plain text of the ICAC Act 2020, there is no legal impediment within that law to the Prime Minister serving as chair of the Appointments Committee. Could there be an implicit conflict with constitutional principles of separation of powers or independence? Possibly, but not an express statutory prohibition. Practical and institutional concerns/risks. 1. Independence versus political influence. When the executive head, the Prime Minister, chairs the body that oversees appointment of commissioners, there is at least a perception risk that appointments are not fully independent from political considerations. 2. Checks and balances. The law builds in checks. The Appointments Committee includes the opposition leader, Chief Justice, Public Services Commission Chairman, and PNG Council of Churches Chairperson. Decisions require quorum and majority rules, so the law attempts to dilute total control by the Prime Minister alone. 3. Conflict with constitutional officeholder protections. Because ICAC commissioners are constitutional officeholders, questions may arise whether it is appropriate for the political head to chair their appointments. But unless tested in court, the statute stands. 4. Public perception and accountability. Even if legal, the arrangement may draw critique from civil society, media, or oversight bodies on whether the arrangement undermines the independent character of ICAC. 5. Future constitutional challenge. If challenged, the Supreme Court might have to decide whether the arrangement violates separation of powers or constitutional guarantees of integrity. Before we conclude, Please like, share, comment, and subscribe to PNG Ways for more contents like this on my YouTube channel. Now let me conclude by saying, the ICAC Organic Law, 2020, explicitly designates the Prime Minister as chairperson of the Appointments Committee, Section 133. There is no section forbidding the Prime Minister from chairing. Therefore, under the plain terms of the law, Prime Minister James Marape can serve as Appointments Committee Chairman. Whether this is desirable for ICAC's independence is another matter. It carries risks of political influence and interference, but legally, the statute permits it. Any challenge would likely need to be on constitutional grounds rather than the ICAC Act itself. If reform is desired, Parliament must amend the organic law or conduct a constitutional review and remove prime ministers as a member or a chairman of appointment committees to prevent political interference. Thank you for watching.